We have to talk about President Trump taking an emergency stay request directly to the United States Supreme Court on the grounds that Judge Juan Marchand in New York State Court is exceeding his authority and violating the separation of powers by trying to sentence President Trump on January 10th. All in violation of the Constitution is the argument made by President Trump and his lawyers. I want to make you the smartest person in the room, so I want to break down this argument because, again, you need to understand the entire tapestry of American law to be the best possible advocates for our Constitution. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist for the 2025 Gundy's Awards in the category of Top Voice of the Second Amendment, Top Voice of the 2A. Always proud to receive an honor like that. Even though we haven't won in the past, we've been a finalist in several categories in the last several years. This year, I think we may break through and win a Gundy's Award. Let's see what happens at the end of this month. All right, folks, so here's the story. I need you to understand this issue with President Trump and immunity. It's going to come up in future conversations, touching fingers with the Second Amendment in future videos. So I just want to talk, for the purposes of today, of what is President Trump's lawyers attempting to accomplish by seeking this emergency stay, which means they're asking the U.S. Supreme Court to stop, put a pause, hit the brakes on the January 10th sentencing hearing. The New York State Supreme Court Judge Juan Marchand wants to hold, basically to sentence Donald Trump to some sort of criminal penalty. Now, he's indicated it won't be prison, but we don't know. But whatever it is, they want Donald Trump to show up on January 10th in New York State Supreme Court, which in New York, the New York State Supreme Court is the lowest court. It's the trial court. It's a lot different than the federal system. So Judge Juan Marchand, as you know, presided over the trial this spring that forced President Trump to sit in a courtroom for like over a month, freezing his butt off as he was tried for a nonsense indictment charge dealing with supposed bookkeeping entry errors associated with how he characterized the Stormy Daniels settlement payments, whether they were legal fees and all these other hooey. Again, we don't need to get into the merits of that case here. What we need to do here is simply talk about the fact that Donald Trump was convicted by a jury in the spring. This is almost certainly going to get overturned on appeal, but that's not the purposes of today's video or this emergency stay by President Trump. But President Trump's argument is this, that in the spring of 2024, you had a trial. And during that trial, Judge Juan Marchand admitted into evidence a whole host of evidence and information and narratives and stories and facts that spoke to actual activity by President Trump in his capacity as president that went right to the core activities of the President of the United States, including communicating with the public, communicating with the staff in the Oval Office about communication strategy, talking about the exercise of the Department of Justice, talking about the exercise of the pardon power, and so on and so on, and including, by the way, completing federal forms that the president has to complete as part of his job of being president. And all of this evidence concerning these issues was admitted into evidence in this trial involving Donald Trump's payments to Stormy Daniels to settle a case. And the argument, of course, in the trial itself was that Donald Trump hid this information from the American public and this violated various laws, such as campaign finance laws, all of which is hooey. But the point is that was the argument made. Now, Donald Trump's argument now is this, that two critical things have now occurred since he was convicted in the spring of 2024. He obviously points out, just generally speaking, that this trial was hooey. It's based on a made-up law. There's no way it's going to survive an appeal. But he says, nevertheless, there's two obvious, clear errors that are occurring right now. The two things are, and this goes back to what occurred after he was convicted this spring. The first thing that occurred that was material after he was convicted this spring is what? The United States Supreme Court decided the Donald Trump immunity case that specifically says that to the extent someone is trying to indict Donald Trump and charge Donald Trump criminally for activities that are within his core competency, within his core functions, his core obligations as the President of the United States. He not only can he not be charged with a crime associated with any of those activities, he can also not be required to give evidence or to provide evidence or have discussions of the evidence associated with that core governmental functions, the core functions of the president. And therefore, Donald Trump is now arguing that because those critical information about his core functioning as the president, including, again, using Twitter to communicate with the public about his views on critical topics, his filling out federal forms he's obligated to fill out, his communications with presidential staff members in the Oval Office, and so on and so on. All of this information that was admitted in the trial by Judge Juan Marchand was improper because it all spoke to the core functions that he engaged in as the President of the United States, and therefore the trial is fatally defective. The trial is fatally infected with evidence that never should have been heard by the jury, and as a consequence, at a minimum, the jury trial verdict from the spring of 2024 must be vacated and thrown out, and if anything, it has to be retried with evidence other than this evidence that was used from when Donald Trump was the president and his work in the Oval Office. That's kind of the first thing. But the other thing that Donald Trump's lawyers are now arguing that is now changed, that justifies the staying, the stopping, the freezing, if you will, of the sentencing hearing on Friday, January 10th, is the fact that Donald Trump in November has now been elected to be the next president, the 47th president of the United States. He is now the president-elect. And the argument is that under a federal statute called the Presidential Transitions Act, this basically gives Donald Trump, as the president-elect, the cloak of the executive branch, the protection of the executive branch. Because as the president-elect, under federal law right now, specifically under the Presidential Transition Act, he is obviously not functioning as the president per se, but the Presidential Transition Act is all about getting Donald Trump as the president-elect up to speed with sharing information with him, helping him get ready for taking over the job so that when he hits the ground running and is sworn in on January 20th, 2025, he is able to step up and do his job immediately. And the argument that Trump's lawyers are arguing here is that he's already won the election. He's already been certified as the president-elect by Congress under the Electoral Count Act. And basically, this January 10th sentencing hearing in New York State Court in front of Judge Juan Marchand violates the separation of powers between the court system on the one hand and the president on the other hand. And given the fact that what Donald Trump is now doing is he's functioning as the president, at least for the purposes of the transition, that to force him to go to New York to be sentenced criminally in a court violates the separation of powers. It violates the Presidential Transition Act, and it simply means it's a no-go because he's essentially immune under the precedent set in the Donald Trump immunity case this past July, when the Supreme Court said that you cannot be indicted or charged criminally with anything associated with the core function of being the president, and you can also not be charged with activities that perhaps extend beyond the core functioning of the president into what are known as the outer perimeters. And there may be certain things that are more borderline unclear whether or not it's a core essential power of the president, but it's still something expected. And if it's expected, even if it's not essentially guaranteed or given to the president as a presidential power under Article 2, let's say, of the U.S. Constitution, it still may fall within the ambit of presidential authority and power given basically to the president by the American people, and thus it can still be immune. And just to jog your memory, what immunity means, this is very important because this is a point that Donald Trump's lawyers are making, but I want to make sure you understand this. Immunity is a special doctrine in the law. And what does immunity mean? Immunity is something that is given to someone, in this case, the President of the United States, Donald Trump. Immunity is something that's given to you that says that not only can you not be charged with a crime and convicted of a crime. Listen carefully. Not only can you not be charged or convicted of a crime, you also are immune from going through the process of being charged and defending yourself. What does that mean? It means that the mere fact that Donald Trump is charged and forced to spend time and money and resources defending himself violates the immunity law, violates the immunity doctrine, because the whole idea is that people such as President Trump who are immune from these kinds of criminal activities not only have an absolute defense to not be convicted of a crime, they're also able to avoid having to go through the process itself, with the notion that the process is the punishment. Going through the process of these cases in and of itself is distracting and therefore is not permitted under these immunity doctrines. And that's exactly what the Supreme Court said in the Trump case in July of 2024. And that is the precedent that Donald Trump and his lawyers are now relying upon. They're saying that if you force me to go to New York on January 10th, if you force me to deal with this criminal sentencing in front of Judge Juan Marchand, you are infringing upon the immunity doctrine that protects President Trump during this transition period. And again, they're pointing out to the U.S. Supreme Court that you need to stop this and nip this in the bud, because the right process is that Donald Trump should be able to take his appeal in the normal course in a basis of an immunity argument and say that I want to argue at the appellate courts that this evidence never should have come into trial that concerned my core functioning as the president, that it was wrong and reversible error for Judge Juan Marchand to admit into evidence my conversations with Hope Hicks, my conversations with other people in the Oval Office, the documents that I filled out when I was the President of the United States that I had to fill out as President of the United States, communications with the American public on various topics. All of these things, including discussions of like my pardon power and criminal law and the Department of Justice, all of these things should not have been allowed into evidence. And I am entitled, because of the immunity doctrine, I am entitled to take an immediate appeal and get final resolution all the way up through the New York State court system, and if need be, to the U.S. Supreme Court itself before I am sentenced. And that is the big issue here. There's a chicken and egg. Which comes first? And what President Trump is saying is because of the immunity doctrine, he gets to take what are known as these interlocutory appeals all the way up to the U.S. Supreme Court, get rulings on these matters before he can be sentenced. And he also points out that he expects that he will prevail in his argument that the trial was fatally flawed and must be thrown out. The jury verdict must be thrown out because all this evidence about presidential core efforts, presidential core powers, and his activities were admitted, and the jury listened to it, and they're not allowed to hear that kind of evidence because of the immunity doctrine that protects President Trump. And because the jury heard this evidence, guess what? The jury verdict is supposed to go away. So Donald Trump has articulated to the U.S. Supreme Court that the sentencing should be shut down immediately, not only because he's likely to win this case on appeal, but also he should not have to suffer through this nonsense and distraction during this transition period under the Presidential Transition Act. And last but not least, it is crystal clear in his mind that this jury verdict will be vacated and this case will be reversed, and that's what should happen. And the U.S. Supreme Court right here, right now, should prevent Juan Marchand, the judge in New York State Supreme Court, from being able to sentence Donald Trump, which of course the left wants to sentence Donald Trump so they can keep calling him a convicted felon as a talking point politically. All right, folks, so to close, there's two issues in this case. One is the official acts immunity, saying that Donald Trump cannot be held liable for his official acts. And the second thing is the sitting president immunity doctrine, which says that he's effectively the sitting president right now under the Presidential Transition Act. And because he's the sitting president in effect for the transition period, he cannot be harassed by a New York State court. So we'll see what the Supreme Court does. If you ask me to predict, I'm predicting the Supreme Court will stay this decision by Judge Juan Marchand and will not allow Donald Trump to be sentenced on January 10th. I think they will allow Donald Trump to take his appeal all the way up through the court system on the grounds that basically this verdict is nonsense and violated, among other things, presidential immunity in various ways. But only time will tell. But it'll probably be decided really quick by by the U.S. Supreme Court, because obviously the sentencing hearing is coming up imminently. All right, folks, hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner. Don't forget to subscribe to this channel and share it with your friends. We're trying to get to 200,000 subscribers. Don't forget to follow me on Rumble. If you're over there, I'm trying to expand that platform because a lot of people like Rumble over YouTube. So I'm trying to post on both places. And again, I look forward to talking to all of you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.